Right now, there's a lot of panic spreading online about a so-called major immigration reform that people claim has already become effective. You may have noticed headlines stating protections are eliminated, green card holders are suddenly deportable, or that one error can finish everything overnight. As of January 2026, those claims are not correct. No new immigration law related to this matter is currently in effect, and no sudden nationwide change has occurred. Welcome to U.S. Policy Brief, your reliable source for the newest information on U.S. immigration, visas, green cards, and citizenship. I am your host, Fernando. The bill driving this confusion is known as H.R. 875, a proposal that has been discussed extensively on social media and in immigration circles. The most crucial fact to understand at the beginning is this: H.R. 875 is not law. It passed the House of Representatives in June 2025, but that was only one step in a lengthy legislative process. The bill then moved to the Senate, where it was referred to committee, and since then, nothing has been completed. Here is what many videos fail to explain properly. For a bill to become law in the United States, it must pass both the House and the Senate in the identical form, and then be signed by the President. H.R. 875 has not finished that process. It has not passed the Senate. It has not been signed. And because of that, it has no legal impact on immigration enforcement today. There is also no hidden or emergency implementation happening behind the scenes. As of now, immigration agencies are functioning under the same rules that existed before this bill was introduced. Even though the bill has political support and continues to be discussed going into 2026, discussion alone does not alter the law. So, if you're a visa holder, a green card holder, or someone planning to apply for citizenship, it's essential to separate facts from online panic. Nothing has shifted overnight, but this proposal still matters because if it moves forward later, it could reshape how certain cases are handled. Understanding that difference right now can protect you from fear-based decisions that may do more harm than good. To really understand why nothing has shifted yet, you need to understand where H.R. 875 actually is in the lawmaking process, because this is where most misinformation begins. H.R. 875 was introduced in the House of Representatives in early 2025 and passed the House in June of that year. That vote is real and it matters, but it is only the first step, not the finish line. After passing the House, the bill moved to the Senate and was sent to the Senate Judiciary Committee. That's where it still remains today. As of January 2026, there has been no full Senate vote, no final version approved by both chambers, and no signature from the President. Without those steps, the bill cannot be enforced, no matter how strongly some politicians support it or how many headlines claim otherwise. Here's something important many videos leave out. Bills can remain in committee for months or even years. The Senate can pass the bill, amend it, delay it, or let it quietly expire. Even if the Senate passes a modified version, it would have to return to the House for approval again before it ever reaches the President's desk. That means there are still multiple decision points ahead, not one inevitable outcome. Another key point as we move deeper into 2026, there has been no implementation guidance, no agency memos, and no enforcement preparation issued to immigration officers related to this bill. That's a clear indication that the federal government is not acting as if this law is imminent. When real immigration changes are approaching, agencies prepare months in advance. That has not occurred here. So when you hear phrases like Congress passed it or it's already active, understand what's actually occurring. One chamber approved a proposal. The rest of the process is incomplete, and until it's finished, immigration law remains exactly where it was before H.R. 875 entered the conversation. That context is essential because without it, fear fills the gap where facts should be. Now let's discuss why this proposal is getting so much attention, what it would actually accomplish if it ever becomes law. H.R. 875 focuses entirely on how DUI-related conduct would be treated under immigration law, and the changes it proposes are far more aggressive than what exists today. If enacted, the bill would create a new ground of inadmissibility based on DUI conduct. That means a person could be blocked from obtaining a visa, adjusting status, or re-entering the United States after travel if they have been convicted of a DUI, or even if they admit to the essential elements of a DUI offense. This would apply regardless of whether the offense is considered a misdemeanor or a felony under state or local law. In practical terms, even a single DUI could suddenly carry immigration consequences that don't exist in most cases today. The bill would also create a new ground of deportability. Under this proposal, a DUI conviction alone could place a non-citizen into removal proceedings without the need for multiple offenses or aggravating factors. One of the most serious aspects here is that the bill does not include a time limit. That means past convictions, even from many years ago, could potentially be used as the basis for immigration action if the law were enforced as written. Another major shift is the removal of discretion. Under current immigration law, officers and judges can often weigh factors like rehabilitation, family ties, length of residence in the United States, and overall good moral character. H.R. 875 would eliminate that balancing in DUI cases. The outcome would be automatic, not individualized, and that's why many legal experts see this as a fundamental change, not a minor adjustment. There's also a detail that has raised alarm among attorneys: the inclusion of admissions, not just convictions. Under this bill, a person could be deemed inadmissible based solely on admitting DUI-related conduct during an interview or interaction, even if no criminal conviction ever occurred. That is highly unusual in immigration law and expands the risk far beyond the courtroom. So, while nothing has shifted yet, this is why the proposal matters. If it moves forward, it would redraw the line between minor criminal conduct and severe immigration consequences, and it would do so in a way that leaves very little room for second chances. To understand why this proposal would be such a dramatic shift, it's important to examine how DUI cases are handled under current immigration law, because the reality today is very different from what H.R. 875 proposes. Right now, a simple DUI is not automatically a ground for deportation or inadmissibility. That doesn't mean DUI cases are harmless in immigration terms. They can still cause problems, but those problems depend heavily on the specific facts of the case. Immigration authorities look for aggravating factors, not just the label of the offense itself. Under current rules, a DUI may trigger immigration consequences if there are elements that make the case more serious. This can include multiple DUI convictions, involvement of controlled substances, causing injury or property damage, driving without a valid license, or situations involving reckless behavior, such as having a child in the car. In those scenarios, immigration officials may argue that the offense falls into a more serious legal category. For people applying for U.S. citizenship, DUI history is evaluated under the good moral character requirement. A single DUI does not automatically disqualify someone from naturalization, but multiple incidents, especially during the statutory review period, can raise serious concerns. Even then, current law allows officers to examine rehabilitation time passed since the offense, steady employment, tax compliance, and family responsibilities. Many applicants with past DUI cases have successfully become citizens under this framework. Green card holders face a different risk, especially when traveling internationally. When returning to the United States, lawful permanent residents are still subject to admissibility screening at the port of entry. Certain criminal histories, including some DUI-related cases, can trigger questioning or delays. However, under today's rules, a single DUI without aggravating factors is usually not enough by itself to deny re-entry. For undocumented immigrants, a DUI arrest can be dangerous for a different reason. The immigration consequence usually comes not from the DUI itself, but from contact with law enforcement. An arrest can lead to ICE involvement, and once immigration authorities are involved, lack of lawful status becomes the basis for removal proceedings. This is the system H.R. 875 would replace. Instead of case-by-case evaluation, discretion, and context, the proposal moves toward automatic consequences. That contrast is why this bill has sparked such intense concern, not because it reflects current law, but because it would fundamentally alter how immigration cases are decided. With all of this information, the most important question becomes practical. What should you actually do today? The first thing to understand is this: nothing has shifted yet. If you have a DUI on your record, H.R. 875 does not suddenly make you deportable or inadmissible as of January 2026. Current immigration rules still apply, and panic decisions based on online rumors can do more damage than the law itself. If you are a non-citizen with any criminal history, including a DUI, this is a smart time to speak with an experienced immigration attorney. Even if this bill never becomes law, understanding how your specific case fits under current rules puts you in a stronger position. An attorney can explain your risk level, help you plan ahead, and advise you on what steps make sense now rather than later. If you are a green card holder and eligible for U.S. citizenship, this situation highlights why naturalization matters. U.S. citizens cannot be deported. If you qualify to apply and you meet the requirements, moving forward with citizenship can provide long-term protection that no pending bill can take away. International travel deserves special attention. If you are a non-citizen and you have any criminal history, even one that seems minor, consult an attorney before traveling outside the United States. Re-entry is often where immigration issues surface, and it's better to know your risks in advance than to discover them at the airport. If you are currently facing DUI charges, it is critical that both your criminal defense attorney and an immigration attorney are involved. Criminal outcomes that appear similar on paper can have very different immigration consequences. Coordinating those two areas of law can significantly affect your future. And finally, the most effective protection is prevention. Driving under the influence puts lives at risk and can create serious legal and immigration consequences even under current law. If this bill ever becomes law, those consequences would be far more severe. Avoiding that risk entirely is the safest choice. As we wrap this up, it's important to step back and examine the bigger picture. Immigration law in the United States is constantly evolving, and Congress introduces thousands of bills every year. Some pass, many don't. And even bills with strong political support can stall, be rewritten, or quietly disappear. H.R. 875 passing the House was a meaningful step, but it was not the final one. And as of January 2026, the law on the ground has not shifted. What this situation really shows is how quickly misinformation spreads when immigration is involved. Fear-based headlines get attention, but they don't help families make smart decisions. Accurate information does. Right now, H.R. 875 is still a proposal. It is sitting in the Senate process, and until it passes both chambers and is signed, it has no legal effect. Claims that everything has already shifted are simply wrong. If this bill ever does move forward, it would represent a major shift, turning DUI-related conduct into automatic immigration consequences with no room for discretion. That's why staying informed matters. Not to panic, but to plan. Knowing where you stand under current law. Understanding your eligibility for permanent status or citizenship and getting proper legal advice puts you in control, not at the mercy of online rumors. Make sure you subscribe to US Policy Brief and follow us on X so you never miss any immigration update that matters to you. This is also a reminder of how important secure status is. If you are in the United States on a temporary visa, having a clear long-term plan matters. If you are a green card holder and eligible for naturalization, citizenship offers the strongest protection against future policy shifts. The more stable your status, the less vulnerable you are to political changes. Don't make decisions based on panic and get professional guidance for your specific situation. Immigration law is complex, and every case is different. Clear facts and careful planning are always better than fear. That's the information you need right now. Honest, current, and grounded in reality.